Sensor. Well, today is our last day. This is the first session of our last day. And for those that might be new to Washington Arbitration Week, my name is Jose Antonio Rivas, one of the co-founders, partnered by Lexecon, a boutique law firm that does investment arbitration, international commercial arbitration, and public international law. One of the elements of Washington Arbitration Week is that we really try to identify topics that may be different and may be novel. I don't really think that this one is or should be that novel or that new, because investment arbitrations, though perhaps created at the beginning for massive projects related to infrastructure or utilities or oil and gas or energy, etc., has proven to also welcome medium and small size companies, and many of which also do contracts. And in fact, the ICSID Convention was created not necessarily so much with the treaties in mind, but it was also created with investment contracts in mind. And at the beginning of the ICSID Convention, the cases that were initially filed were contractual cases. Now the tide has turned significantly, and most of the cases are treaty cases. But the contract cases were at the beginning, and now other institutions have made some sort of a push for more contractual disputes amongst between sovereigns and investors. So this is, to some extent, the subject of today's panel. But my job is not to go deep into the topic. That is for the wonderful panelists that are here. I would like to especially introduce David Attanasio, who has been a staunch supporter of Washington Arbitration Week, and he's the moderator of this panel. David is a partner at Womble Bond Dickinson, who resolves cross-border disputes through international arbitration and transnational litigation, with deep experience in energy and natural resources and a strong focus on Latin America. He has been recognized by chambers in the United States as up and coming, by Who Legal as a future leader, and by Legal 500 US. He is known for incisive advocacy on complex public international law issues. He also advises on business and human rights and other public international law mechanisms, and has appeared in US federal courts. David has taught international arbitration at George Law and serves on the board of the International Law Association American branch. He has co-authored International Investment Protection of Global Banking and Finance, and authored State Responsibility Based on the Actions of Private Actors. So with that, welcome David, and thank you for moderating this panel.
Thank you very much, Jose Antonio. It's an absolute pleasure to be here this morning to close out this year's edition of Washington Arbitration Week. We're now in the 6th year of this conference, and I have to just give my deep thanks to Jose Antonio and his team, also to Ian Laird, for creating this really emerging new institution in the Washington arbitration scene. It's become an important contributor to DC's thought leadership in this space. And today we have a really fascinating panel, Arbitrating Contractual Disputes at ICSID. Is there an actual or likely rise of contract claims in the context of ISDS reform? This is a timely panel. I can't take credit for the idea. All I did was express interest in speaking on this particular subject, so that I think the credit goes to Jose Antonio and his colleagues. But I think it's a really important topic to be addressing right now, especially in the context of the wave of reforms in investment treaties, termination of treaties by many states, or or implicit terminations in other cases that have decreased or threatened to decrease the network of treaties available in the future for resolution of investor-state disputes. So I'm thinking about things like the ECT modernization, the ways the European Union has, the attitudes the European Union has taken towards the ECT and other treaties in the context of relations between its member states, reforms of NAFTA and its replacement with the USMCA and potential further changes in the coming days, and then even just the newer waves of bilateral investment treaties that have been that are supposedly more modern, but also in general potentially less protective of foreign investment. So for the since the boom and investment treaty arbitration, contracts have not really been at the core of investment treaty protection. But with these treaty options becoming more restricted, it's time for a second thought as to the role that that contract-based arbitration might have in international investment protection. And of course, the lack of investment treaties does not mean that foreign investors are uninterested in protection. Historically, if we look back over the course of the 20th century, foreign investors have always sought means to find protection against what they considered to be adverse actions by foreign governments. And just looking historically, we can think about things like claims commissions, which would handle mass claims by foreigners who felt that their investment or persons had been adversely affected, regular state-to-state dispute mechanisms, either through arbitration or various judicial fora, or even non-legal mechanisms that have been used in the absence of law. So political negotiation, either at the international or domestic level, or in the sad state of affairs at the dawn of the 20th century, diplomacy. But going forward, if investors perceive investment treaty protection as weakening, contractual mechanisms may be the most feasible and most directly under the control of foreign investors, at least in our current legalized world commercial order. So we have a fantastic panel to discuss this set of issues. Could not have chosen a better set of experts on these topics. So first, to my left, we have Aurélia Antonietti, who is a senior legal advisor at ICSID. She's been with ICSID since 2003, so an over 20-year tenure there, with just a small gap from 2006 to 2008. In addition to her extensive experience and perspectives that she's gained from ICSID, she's also had some time in private practice. But given her position at ICSID, Aurélia really has her finger on the pulse of the developments in investor-state arbitration, and she actively contributes to discussions on current trends and future developments, including, as I understand it, in the context of the ICSID Working Group 3. To Aurelia's left, we have Timothy Tyler, who is a counsel at Norton Rose Fulbright in Houston. His practice covers the gamut of international arbitration counsel work, including investor-state, commercial arbitration, and related U.S. litigation. Tim has also taught international arbitration for many, many years as an adjunct professor at UT Austin. To his left, we have Jeremy Sharpe, who is currently a well-known international arbitrator. Formerly, he was a partner at Sherman & Sterling's international arbitration practice, and he also served as the chief of investment arbitration in the Office of the Legal Advisor at the U.S. Department of State. And to Jeremy's left, we have Miguel Nakhle. Miguel Nakhle is an executive vice president at Compass Lexecon, based in Houston. He has over 20 years of experience in economic and financial consulting, particularly in relation to quantum, in over 50 international arbitration matters. So he routinely acts as a quantum and economic expert witness, and has testified in some 20 matters across various industries and jurisdictions. So with those With those introductions of our extremely qualified panel out of the way, I would like to turn the floor over to Aurélia to give us a brief historical introduction to contractual disputes at ICSID and also to present some statistics from ICSID regarding contractual disputes.
Thank you, David. Good morning to all. So I'm here to plan the decor, basically. Historically, it's going to be very short. The first ICSID case, registered was Holiday Inns versus Morocco in 72, and it was a contract-based case. And just to refresh your memory, the first investment law case was registered in 94, and the first BIT in 87. So the first year of ICSID were contract-based, and the number of contractual arbitration has been steady, but of course it was overtaken by BIT cases or treaty cases in the 90s. So what I'm going to do today is give you an introduction in terms of statistics. I like statistics. So we have, so I'm sorry you have to strain your neck because the slides are behind your back, and maybe if you are on the side, you want to go in front, I don't know. But you will have to do a bit of ICSID side here. We are sorry for that. So that's just the ICSID membership, 158 ratifying states. In yellow, the states that have signed the ICSID Convention but not ratified yet. But going to cases. So that's the overall number of cases registered at ICSID, 1,058 cases. This year, fiscal year 2025, we registered 67, so it was a pretty high year. The number of cases are consistent. And you will see from the slide that most of the 90% of the cases are based on the ICSID Convention, with 8% of additional facility, which is another set of rules, and some slight conciliation compared to the full number. But when we look at those numbers, and those numbers, by the way, are available on our website. We publish twice a yearly statistics. So that's the latest statistics as of June 30th, 2025. To add to those cases, we also administer ancestral cases, and that's important because some practitioners do not know that. But we do administer ancestral cases. So in terms of contract, yes. So contracts represent 15% of all ICSID cases. And we had 173 contract cases so far. We are going to publish later in the year a background paper on contract arbitration under ICSID. It's not ready yet, but we are analyzing all those contract cases. And so in terms of cases, it's kind of the same thing. It's 91% of contract cases under the convention. And then you have conciliation, maybe more conciliation than regular cases, 9%, and there are usually mandatory steps. There are usually mandatory steps in the multi-clause steps, arbitration clause, so they're usually the first step before arbitration. Moving on to, just to give you an idea, that's the general basis of consent at ICSID. So you see that BIT is 58, treaties mostly, and contract is 15%, and investment law 7%. So going back to contract, I think what is interesting is to kind of compare, and I don't know if you can really see the comparison, but in terms of geographic distribution, in regular cases, so all cases, Eastern Europe is 24%, followed by South America at 21%. And if you add that to Central America, you have 29% of cases, followed by Sub-Saharan Africa, 15%. But in contract cases, Sub-Saharan Africa represents 46% of the cases. So that's very interesting. And of course, it's because of the mining, mostly of the mining contracts and mining concessions or license or permits. South America is at 21% with 10% of Central America. So Latin America as a whole is also 31%. What is also interesting is to compare those with the origin of the investor, right? So in usual cases, you will see that Western Europe, which is at the bottom, is always where the investors are coming from mostly. in all cases is 44%, in contract cases is 31%. Then the next are North American investors, so it's 17% in the case of contracts. And then what is interesting is you go up for cases with involving sub-Saharan African cases, states, you will find 70% of cases involving an investor, a local investor, and that's pretty rare. And that's also south to south, think of it in the south to south arbitration aspect of it, but it's basically all those investors parties are locally incorporated entities, what we call the 25(2)B companies under the ICSID Convention, and they are under foreign control. And the main foreign control of those locally incorporated entities are US, France, and UK. So now if you look at the economic sector, there is no surprise there. Oil, mining, and gas is representing 46% in contract cases of the sectors used, followed by electricity, and other energy. So it's kind of match what is happening in the old cases, but with bigger numbers. Sorry, next slide. So next slide is quite interesting. So we had 133 concluded cases. So basically we have 40 cases pending. And if you compare the outcome of the concluded cases with all cases, so in all the cases, 66% of the cases are decided by the tribunal, and you have 34% of the cases that are settled or discontinued. Okay? And in contract cases, you have 57% of the cases that are decided by a tribunal, and you have a higher rate of settlement or discontinuance, 43%. And when we look at the 43% of settlement or discontinuance, we find that it's mostly discontinuance by one party or by both parties. So it's really settlement, and with a good number of consent awards too. And less cases are discontinued for non-payment than in usually all cases. So it's really, there is a fair amount of settlement in contract cases. Now I'm going to look at the parts where the tribunal decides the disputes. So in all cases, you have 49% of the awards that are upholding claims in part or in full. So that means when the claimant is winning. And you have 51% of cases that are dismissed either on the merits or on jurisdiction, or for lack of manifestly lack of legal merit. But for contract, what is interesting is that the awards upholding claims in part or in full is 65%. So that's where the claimant is winning if more than in contract cases than compared to all cases. And the case and the dismissal is about 35%. And now we also, so since this year, what is interesting in our stats is that we started to have stats on damages, which we didn't have before. And so if you look at you compare the contract cases to all the cases, where no damages were awarded at all, either because there was a violation, but the tribunal decided, for example, that there was no damages. In all cases, it's 54%, one in contract is 37%. And those damages, what we count as damages, is the principal amount claimed. It doesn't include cost or interest. What is also interesting is that most of the cases are, I'm speaking of contract cases, are the damage awarded are under 50 million. But that's also match the trend in all the cases. And the ratio, so we're speaking of 76 cases decided by tribunal, and we also look into the ratio between the damage claim and the damage awarded, right? In some cases, in all the cases, claimant will get less than 10% of the amount claimed, and that's 21% in all the cases when it's 13% in contract. It's also, if you go at the top of the chart, it's also interesting to see that the ratio awarded is between 76 and 100%. In those cases, it's 36% of contract cases, but only 21% in all treaty cases. So you will tend, the claimant will tend to obtain more under a contract case. Last slide I wanted to discuss because it's annulment. It's one of the post-award remedy under the ICSID Convention. Is the most used award post-award remedy. And so we had 85 awards rendered under contract case based, 28 annulment proceedings. The applications were rejected in 43% of the cases, when it's 61% in all cases. Annulment were granted in 25% of those cases. 7 awards were annulled, 1 in full, and that was Klockner versus Cameroon, 6 in part, but I'm going to tell you, to give you the name of the award, and you will realize what it was. So it's AMCO versus Indonesia, annulled twice, Mine versus Guinea, So they are really the historical cases with the first annulment. And then more recently was Occidental versus Ecuador in 2015, RSM versus St. Lucia in 2019, and Perenco versus Ecuador 2021. So there is a good number of cases that were annulled historically before basically the 90s. And the really cases where it was the first attempt at annulment, and we don't know, probably those would not have get the same result nowadays. But it's interesting. I mean, in terms just of sheer number, although it's only 7 awards, but in terms of sheer numbers, the annulment in contract case, granted the rate is higher. We also have more discontinued application in annulment, which could be that there is also more settlement in annulment proceedings. So that was planting the decor in terms of numbers at ICSID.
Aurélia, thank you very much for that. That was absolutely fascinating. Following on that presentation, what do you see as the major advantages and disadvantages of using ICSID for contract-based disputes?
So I'm trying. So trying to summarize the advantages, of course, you have a specialized and neutral institution. ICSID is an intergovernmental organization. It's not private practice. It's not a private entity. We are affiliated with the World Bank with a large membership, 158 countries. We have administered the vast majority of ISDS cases. It's also a depoliticized system. You don't have diplomatic protection. You are operating under the ICSID Convention, which creates international obligation for states at an international level. It's a balanced system, and we like to say that because in the sense that it caters to the interest of investors or claimants, but also states with special procedural rules and features that are for both, and that's very important. And of course, it's a self-contained system. So which means that it's a delocalized, it's independent of domestic courts. One consent is given, it cannot be withdrawn. The main aspect of it is that the awards are final and binding. They cannot be appealed in front of local court. They are subject to only remedies in the convention, which are mainly annulment, but we also have interpretation and revision. And most of it, it's a simplified enforcement mechanism, right? So what a party seeking recognition or enforcement needs to do is to present a copy of the award certified by the Secretary General to local courts. And the ICSID contracting states, so the 158 contracting states, have undertaken to recognize the award as a final judgment of its courts in that state. So that's really the main feature, right? For compliance, if you are interested in compliance, I refer you to the background paper we did on compliance of awards, because there's some kind of really interesting statistics too. It's on our website. I think it was published maybe 6 months ago, but it's an interesting paper. I think what is also interesting for us to administer cases is that we can coordinate or consolidate cases. So you may have an investment case, but you may have a case, maybe a treaty case, under the ICSID Convention, and you can have a contract case also under the ICSID Convention or under the additional facility that we can consolidate. And basically you can have the same hearings, and so you can save cost and time, and that's a possibility. And I think for contract it's very important, because sometimes you have an investment agreement with the states, but then you will have an agreement with state entities. And so you could administer both cases at the same time, maybe having the same tribunal, but basically de facto consolidating the two cases. Last thing, in terms of why would you do under a contract or rather a treaty? For contracts, the states can be the claimant. This has happened in 2 cases. The states can bring counterclaims, and that's very important, right? But also you can tailor your arbitration clause to as the party wants, right? So you can have a cap on damages. You can decide what will be the interest rate. You can decide, or you can indicate some factors as to that. So that's I think the main advantages of ICSID. Then you have the disadvantages. I'm not going to, and I don't know that there are disadvantages, but there are things that parties need to think of, including of course, the threshold and the requirements of Article 25 of the ICSID Convention. But that's a matter of drafting, I would think, and that when the parties are defining clearly in their contract what is the investment, we never had a case in the contract case where the tribunal said there was no investment. But it's all a matter of defining the investment in the contract and making sure that the parties will meet the threshold requirement. Last point, we have 28 cases actually in contract with state entities or agencies. And that's very important. But to come with a state entity as a claimant or as a respondent in ICSID, you need first that the entity has been designated to ICSID. Second, that the consent of the state entity has been approved by the state. So that can be explicit or that can be implicit, but there is quite some jurisprudence about this. And we had a fair amount, maybe 9 cases with Bangladesh, where that was an issue, because, for example, the state signed the investment agreement, the state entity signed the investment agreement, they signed the same basically contract, but doesn't say that the states consent to the state entity's consent. So that should be clearly indicated in the contract, because that was an objection. That was raised as an objection.
Could you do that one more time slow?
Yes.
Yeah, there was just one too many.
So you have a state signing a contract where the state entity is also a part.
Right.
Okay. The fact that the state signed the contract with the state entity doesn't mean, I mean, there was an objection to that, doesn't necessarily mean that the states consent to the state's entity's consent to arbitration. That has been raised as an objection, that there was no state consent, although they signed the same document.
So undone by the meta.
Yeah.
Yeah.
That's implicit, but that's something that the parties may want to clearly put on paper, just to not have those objections raised later on in the proceeding.
Just, and was the objection successful or unsuccessful?
It was not successful because implicit consent was found, but it was still a procedural objection. So it was
expensive.
Yes. So that's why I'm saying parties may want to be sure and to be very clear when they're entering into that kind of contract.
Thank you very much. Now turning to Tim, in your view, what incentives exist to have ICSID clauses as compared to ICC, LCIA, Musatral, or some other option in contracts or investment contracts?
Okay, thank you. I'd like to preface this by saying well, both Miguel and I are from Houston, so in some sense, we're channeling and representative of the interests of energy investors. So largely claimants. Although my first big energy cases were actually representing a state in a contract case. But again, the constituency is foreign investors, and usually under production sharing contracts, those kinds of agreements. And again, you'll see the same kind of thing, or you have seen the same kind of thing in power. And as we just heard, right, power, oil and gas, and then mining account for, I guess, about 25% of the ICSID cases. So the constituencies that I've been talking to, I talked to just a bunch, picked up the phone and called a bunch of friends, were largely reflective of a sense that I've had, which is that the headlines is that degrading protections in bits mean that there's going to be contracts. I don't think that's any news flash, but indelicately put, I think there's no incentive to have an ICSID convention clause, at least as I've been hearing. And so, in other words, a clause where you provide for an ICSID convention arbitration as opposed to, say, the prototypical UNCITRAL rules arbitration enforceable under usually the New York Convention, but any number of others. And again, and the kind of way of thinking of this is one of the explanations was what is it? And I thought there's a wonderful phraseology for it. What is ICSID's value proposition, right? And ICSID's value proposition, viewed through the eyes of claimants, is that the exclusive and internal annulment process, right? That's the big trade-off. The flip side is no second look in a New York Convention Article 5 type proceeding. That is, at least the perception is that if you can't proceed to enforce in multiple forums at the same time as you could do under the New York Convention routine, and you're, as it were, stuck in an ICSID annulment, because that's that's tended to be the playbook. You're stuck in ICSID and you can't go out and seek to enforce simultaneously in a number of jurisdictions as you could under the New York Convention. So that's the centrality trade-off has not, at least in the thoughts of a lot of these companies, has not worked out. The second the second kind of advantage of the ICSID centrality mechanism was annulment, internal annulment plus theoretically faster enforcement at the back end because of no second look, right? The annulment trade-off has had the perception, at least in the community that I'm representing, is the annulment trade-off has not worked out. Annulment is a crapshoot. It's viewed as more of an unknown than would be the case of a set aside in any number of kind of the significant commercial jurisdictions. So that has tended to be tended to kind of dampen enthusiasm for it. And I would say kind of the Rockhopper one took us all for a real loop because everybody compared it with the kind of the set aside jurisprudence of their own jurisdictions, and I don't know if it would have come out the same way. There's nothing quite like that. But that has been the annulment has been a barrier to adoption of an ICSID clause. Enforcement speed. Again, this could be a perception. I'd be interested in the statistics of it. But if you took an ICSID annulment plus ICSID plus an annulment, as opposed to a New York convention, an unstrong New York convention in, say, Geneva, I think your timelines are looking considerably shorter in the UNCITRAL Geneva proceeding or UNCITRAL London proceeding than they are in an ICSID proceeding. And if you combine this with the fact that under ICSID and under the New York Convention, you have the same regime, there's the same joker in the deck, where there's the same concept of sovereign immunity, you're still going to have to overcome that hurdle, right? Regardless of which convention you're in. Given kind of the history that we saw, and this was in spades in the Argentina cases, right? That voluntary compliance is questionable, right? Or is at least the fact that things took so long to get to a resolution where eventually they had to be swept up in funding arrangements makes the business people for the oil and gas upstream and energy investors that they say like, you know, why would we do this when we have greater speed and greater kind of diversity of enforcement forms under the New York Convention routine. So gone are the days of CME in the Czech Republic where the Czechs just wrote a check. And I'd say would see the same kind of Argentina Part 2 perhaps in the Spanish solar cases. Again, you're seeing the same fairly extended timeline with regard to those cases as well. So the advantage in speed, the hope was, and I think it's meant to be structured as an advantage in speed, but we didn't see it, right? Jurisdiction, advantages in jurisdiction. We just heard the undone by the meta problem, but again, that can be gotten through, that can be certainly got at by good drafting, but at least under treaty cases, and I was relieved to actually hear that there were no contract cases that found no investment, because I had the unhappy fortune of being in the Joy Mining against Egypt case, which was one of the very first where no investment was found. And so we were all very concerned there about what's going to happen under Salini, right? The fact that there's this Salini test that lurks out there, even in a contract case, and so that's mitigated by this, the kind of objectively, I think is something that would counsel toward going with an UNCITRAL clause case. So I've said that there's there are more data points really for set-asides and refusals to enforce under the New York Convention, and I think at least in the quarters that I know, they're more comfortable with that greater set of data. Finally, and I think this is interesting, and you could play this either way. There's evidence that we think about from model form model form production sharing contracts. And again, we could say, I don't know which constituency this interests, but we've seen as it were, a market move toward UNCITRAL. The 2016 Guyana PSA, the 26 Guyana PSA with ExxonMobil has CNOC and so forth. Those were ICSID. The 2023 Guyana model PSA is UNCITRAL. Again, that's a fairly, and to this I'm thankful for my friend Richard Deutsch at Pillsbury who gave me these data points. But the move toward UNCITRAL, I think, might reflect that concept. The 2021 Nigeria PSC with Total, it used to be the Nigerian arbitration law or the Nigerian Arbitration Act, and now I think it's UNCITRAL. Yeah, the 2023 Nigeria concession with Total is also UNCITRAL rules arbitration. So empirically, I think that what I'm hearing is I would rather take my chances with an UNCITRAL based case seated in Geneva or London than with ICSID. That being said, ICSID does administer UNCITRAL cases, but and I was particularly intrigued by the statistics there because I was hoping there was kind of more. I was hoping there was more, and I'm wondering if we might see it But I think then you're seeing a greater participation in the market by a larger number of market players, right? Would the choice be ICSID, ICSID as the administering organization, or the PCA, or the LCIA? I think those choices, the latter choices, are what we've tended to see, at least in discussions when things are being drafted. So on the objective case, I'm not seeing a growth in ICSID contract cases, especially under the ICSID convention itself. And there will be an interesting question about that, Mike, whether ICSID would administer the use of ICSID to administer an unsatral case. I've not, frankly, not thought of that in detail, and that might be a interesting value proposition to explore. Finally, and this is kind of open to discussion. I'd be interested to know what value funders are placing on, if there are any, on ICSID convention contract cases versus unsatral rules clauses. I don't think anything has resulted in a case or an award on those, but I'd be interested to see how when you're trying to get some kind of front end view, what a funder would think. And so that could also come out in political risk insurance kind of premium, right? Is there some proxy in the market for that difference in value, and could we get something that, but I'd leave that to economists who are far more qualified than I am. So that's all I have to say. Thanks.
Tim, thank you very much. Turning to Jeremy, in your view, does the diversity of investment contracts limit the prospects that contract-based disputes at ICSID will significantly expand in number?
Thank you very much, David, for organizing this excellent panel. I'd also wanted to extend my thanks to Jose Antonio and to Ian, and really commend the organizers. I think this Washington Arbitration Week has been, as far as I'm concerned, the best that I've seen yet, and you guys have done an extraordinary job. I do think, David, on your question, that the diversity does impact this question about the utility and whether the availability of ICSID arbitration. I mean, if you think about two aspects, the dispute resolution provision in these international investment contracts, and then the governing law, you see a lot of diversity across these contracts. And perhaps it's useful to compare them first against international investment agreements. You see diversity there as well. You see a lot of options, as Tim was just mentioning, unsatral arbitration, ICSID arbitration, other institutional ad hoc, even references to domestic courts. But generally, the investor has the option to go to international arbitration, often ICSID arbitration or unsatral. And that's not always the case at all with international investment contracts. These are often negotiated instruments or not. They are mandated by the host state. And host states oftentimes want to have disputes resolved in local courts, even though a neutral forum may be the most important, or certainly one of the most important things that an investor might be looking for. But it simply may have no option, or this is something that gets negotiated. These issues are all subject to policy choices, negotiating dynamics, legal constraints of the state. And so we will not always end up with an arbitration option, certainly not an ICSID option as well. The same goes for the choice of law. Again, the host state may want host state law to apply, and that is, in fact, what we find often in the case. Again, contrasting it with international investment agreements, again, we see a lot of variation, but you tend to have strong substantive protections in treaties, fair and equitable treatment, expropriation provisions, non-discrimination, full protection and security. You don't often see this panoply of protections in international investment contracts. You might see strong substantive protections. You might even see international law protections, like protections against expropriation. There may be economic equilibrium clauses or stabilization, but it's very different. As I said, these are often negotiated or they may be mandated by the state. So what do we see? We see reference to the home state law, sometimes reference to the host state law, sometimes references even to the home state law of the investor if it's negotiated. Sometimes foreign law, like English law is the government law of the contract. Often see a reference to transnational law, sometimes with further elaboration, like references to the Unidroit principle, or some other explanatory or some reference to transnational law, and not infrequently some reference to international law. I think the ICSID survey, I don't think your report is quite out yet.
No.
If I understand well, the empirical evidence from ICSID, which will be published soon, please correct me, Aurélia, if my statistic is wrong, but I think about 50% of the investment contracts surveyed had a reference to the host state law as the applicable law. And as I said, sometimes there's a reference to transnational law, sometimes international. But even then, if there's a reference to transnational law without further elaboration, there's a question mark about what actually the tribunal might look to, or even the parties in the implementation and interpretation of their agreement, like reference to lex mercatoria, sometimes more specific, as I said, to the Unidroit principles, or even international law, principles of international law, rules of international law found to be applicable or relevant, or some other qualification that leaves some doubt over the exact content and contours of the law. And then the further complication in some of these agreements is a reference to multiple sources of law without always clarification about how these relate. Sometimes you have a reference to the use of dépêchage, so different parts of the contract are governed by different substantive laws. You have oftentimes a hierarchy. Domestic law is the hierarchical source, and international law may be a subsidiary means. You may have a complementarity where domestic law applies, except insofar as it's found to be existent, and then you may have international law as kind of a gap filler. Or you may have international law as a kind of interpretive guidance. So domestic law to be interpreted consistent with international law. So there are lots of ways that parties have used applicable law through their negotiations, each trying to seek their policy preferences, but leaving things oftentimes very confused for the decision maker as to precisely how these things will relate. Which is why I think we often see parties, investors, seeking to use international investment treaties through an umbrella clause or even through an MFN provision, importing an umbrella clause to try to, they argue, elevate this contract dispute to an international treaty level, so to get these substantive protections, to sometimes deal with some of these challenges that might be found, questions that might be found in the underlying international investment agreement.
Thank you. And how might recent efforts at Unidroit and the ICC promote the uniformity of investment contracts?
Yeah, thank you. For those who are not aware, there's a project ongoing right now at Unidroit, the International Institute for the Unification of Private Law, in conjunction with the ICC, to look at international investment contracts. And I think the sense was there's so much focus on the reform of investment treaties, but as Aurélia has pointed out, Tim confirmed, international investment contracts remain incredibly important. And it's not like this is lost on states. I think Tim intimated as well with some updates to states' agreements. There are lots of states that have model international investment contracts. There are lots of developing states that have models as well. But it is not always clear that these agreements reflect best international practices or maybe incorporate some of the lessons learned from international investment disputes over the past couple of decades. So UNIDROIT and the ICC are working on an instrument, and the concept is there would be principles, like the UNIDROIT principles for international commercial contracts, there'll be principles for international investment contracts, commentary on those principles, and then model clauses or references to the many model clauses that exist, whether at ICSID or other institutions, for international investment contracting. The idea is, what works in the UPIC principles, but what needs to be modified or added to make such principles relevant to the unique aspects of international investment contracts, which have their own peculiarities. Of course, you have a state involved, and you have different equities, so forth. So the idea, if we go back to our previous discussion about this uncertainty with choice of law and choice of forum, we could probably help deal with some of these problems. It may be possible to have greater references to international arbitration, which I think is a big priority for international investors, and also give clarity to this applicable law problem, which uncertainty has costs in contracting, and to have an applicable law provision, the provision setting out the rights and obligations of the parties, have a lack of clarity around them. The relationship between domestic law and international sources creates a lot of problems. So to have principles of international investment contracts that could be incorporated as soft law by the parties in their international investment contracts, one hopes would go a long way to solving some of these problems and to bring in some of these developments that we've seen in international investment disputes of the past 20 years, whether it's to the environment or ESG or these sorts of questions. Developments in stabilization or economic equilibrium clauses. There are lots of developments that we've seen, but they're not always reflected even in contracts concluded today. So UNIDROIT and the ICC hopes to send out this instrument for public consultation, I believe in more or less early 2026. And I hope experts such as yourself will be taking a look and providing feedback to try to make this as useful for users, investors, and states going forward. And one hopes will increase the utility and availability of ICSID arbitration, I think, going forward, as well as other arbitration form. Thank you, David.
Thank you. And now moving on to the economic side of contract-based disputes. Miguel, in your experience, what are the key differences when assessing damages in a contractual dispute versus a treaty dispute?
Thank you, and thanks everyone. Thanks for the invitation to Washington Arbitration Week. So in my experience, it can be very different. I mean, on the surface, when we as quantum or damages experts approach these international arbitration cases, and there's going to be a number of claims, and in principle, one could say that the goal of compensation in both contractual and treaty disputes on the surface is similar, right? Normally, with treaty disputes, it restores the investor to the position they would have been in, but for the treaty breach. With contractual disputes, put the injured party in the position they would have been in had the contract been performed. So they sound similar on the surface. Now, in treaty disputes, the difference is that that's pretty much the only guiding principle that we have. And we implemented following the very well-known Georgia approach of full reparation. So effectively calculate the compensation that will wipe out the consequences of the illegal act, reestablish the situation that would, in all probability, have existed in the absence of the breach. And many of these treaty-based cases, when we get to damages, that's the principle that we follow. It's effectively that. It's a very powerful principle, but it can also be very broad, and it leaves a lot of discretion on the tribunals and the experts when they put forward these assessments by following that principle. Just to give you an example, one of the longest cases that I've been part of was the AES versus Argentina case, which the award came out this year. over 20 years of, that case lasted for over 20 years, and it related to changes in the regulatory framework for the power sector in Argentina. So effectively, what we had to do is build a but-for or counterfactual scenario for over 20 years. This was all historical damages. There was no expropriation involved directly, but the bulk of the case was historical damages for 20 years building this but-for scenario. So you can imagine how complex that exercise is. Even though we are not forecasting anything, we are creating an alternative reality for 20 years. So there were major discussions on issues like pre-award interest rate. You are assessing damages back of 2003. The interest rate that you use to update those can create a huge difference in the compensation. Discussion of whether, for example, those counterfactual profits, put it simply, of the company should be discounted back to when the measures first started. Right? There was an argument of that. How do we account for the risk that these are counterfactual? This is historical, but at the same time, they are counterfactual. So there's a lot of issues that arise from trying to apply this principle of wiping out the consequences of the breach, creating these appropriate but-for scenarios. Now, when we come with, again, we come and deal with contractual disputes. Now, as I said, the principle on the surface is similar, but the contracts would normally have a much more specific language and remedies that we need to abide by the way, because performing the contract can also mean applying the contractual remedies for the breaches, right? Contracts will normally have liquidated damages clauses. So, we encounter those routinely. Just to give you another example, wind energy producer of turbines that has this contract with the operator, and the contract has a liquidated damages clause, right? So if there's a non-performance of the turbines, there's a formula that you apply, and you get the formula, by the way, was in these particular contracts based on a lost revenue formula. So you would think about it something kind of like a but-for, right? If the turbines perform, you obtain this extra revenue. So that's what the LD, so the liquidated damages, wanted to approximate. But that has a limitation normally in the contract. There's a cap that the parties would agree on. Now, we are, as quantum experts, we're going to apply the clause, but also we need to discuss with counsel what is the legal theory around it, because, for example, in this particular matter, you may have an allegation of gross negligence or willful misconduct that would allow the party that suffered the breach to go around those limitations. And now we may end up in a but-for versus actual situation as the one I was describing before. And this is what happened in these cases. So now, should we apply the clause? Is the LD, should we apply the LD but remove the limitation, or should we move away from the LD formula, which was conceived to be a remedy under that particular limitation, to more of a traditional but-for scenario, which can be very, very different? Because now we have to account, for example, of the cost of replacing that energy that was not produced by the turbines. Right, so we need to put the agreed party in the same position. So maybe the lost revenue is not enough. Maybe the lost revenue is too much, because there are associated costs with producing those revenues, which the LD formula doesn't account for. So in that sense, I think that the contract is a much, if you are going to abide by those clauses, it's normally a much more specific and limited. Another example, and going back to Tim's mention of energy companies, a lot of these contracts of oil field services, for example, with state-owned companies. We have seen many cases, we face a situation of non-payment, right? So we have several years of the state-owned entity not paying the invoices on time. That accumulates. Eventually, this comes, there's a case about this, an arbitration to try to collect this. And then the question is, do we apply the remedy of the contract? The contract may have, for example, an interest rate for those debt. It may have a way to whether to use simple or compound interest. Do we need to speculate on a pre-award interest, or what the party would have done had it collected the invoices on time, or we just simply compute the outstanding debt according to the contract. So I think in that sense, we may not even need a but-for scenario for that case. We're just going to follow the contractual provisions for lack of payment. And then one last difference that we've seen, for example, that I think is very important is that in treaty cases, particularly now, I talked about the mostly like non-expropriatory claims, but if you do have a lawful and unlawful expropriation, it is fairly well established that the date of valuation can mean, and particularly in an unlawful expropriation, whether you account for the events that happen after, they increase the value of the asset being taken, they are normally accounted for. If not, you assess the value as of the date of the taking. That's not necessarily the case in contractual dispute. You may have, for example, a breach that the contract was terminated on a particular date, and then between that date and the date of the arbitration, there were events that mean that the contract would not have been as valuable as it was expected back when it was terminated, for example. Now, do we account for those events or not? And there's this famous case, I think it's an English contract law case, the Golden Trail versus NYK line, which I think is very interesting because it's fairly simple, the facts. So this is a shipping line that had chartered a vessel, and it was supposed to keep the vessel chartered until 2005, terminated the contract in 2001, and then by the time they get to the arbitration, they realized that by 2003, they could have gotten away from the contract because there was a clause saying that there was a war between the US and Iraq. They could terminate the contract on that basis. Now, the arbitrators decided, well, then you would only be entitled for 2 years, not the entire length, because that would have been terminated anyway. There was a dissenting opinion of saying, no, you should put yourself at the moment in which this was terminated. There were 5 years left in the contract. Had they paid compensation promptly, that would have been the compensation. So I guess you could see it from both sides, how that's now a matter of discussion for this type of cases. And then one last point that we've encountered in not being lawyers, but we've encountered in practice is the issue of sometimes reflective losses, no? Or indirect losses in treaty claims. It is very common to see shareholders of a local entity bringing claims based on their stake in the local company. When you go through a contractual or more like commercial law, sometimes that's not allowed. Many times it's not allowed. So shareholders may not bring a claim based on the reduction of the value of their stake in that particular company if the measures were against the company and not directly the shareholder. So that's another difference. So there are various differences that we've seen, again, not being a lawyer, but when we approach these cases, I think it's very important to keep that in mind. We have the overarching principles may be similar on the surface, but then the contract would prevail and that can change the approach significantly.
Thank you.
Go ahead, before you ask the floor. Before we open the floor, I just want to answer to Tim. Presentation. I think that's. I mean, it seems to me that it's a matter of perceptions, and I'm very grateful that you actually ask practitioners and oil and gas people.
Yeah, it helps, yeah.
It helps, but I also think that people perceive that as all ICSID cases and mostly treaty cases, which, that's why we are doing special stats for contract. That's why we are doing a contract paper. That's why, and because I think if you just have to also compare those ancestral contractual cases with ICSID contractual cases, and maybe you will have the same idea in terms of duration. I know that contract cases are not as long. You don't have the same objection on jurisdiction. So I think you have this perception of ICSID, which is mainly based on treaty cases. And that's what we are trying to correct.
And so we're close to the end of our session, but Miguel, briefly, do you think that a shift to contract-based investment disputes would address concerns that damages awards are too high?
Well, I think it plays really well in, with the statistics that Aurélia showed us earlier this morning. I mean, first of all, this notion, just for the record, this notion that damages awards are too large. I think that, at least in my view, the evidence that I've seen is simply looking at the data and seeing that the average size of an award has been increasing over the last decades or so. I don't think that means they are excessive necessarily. You have to see what's under the hood there. You can just simply say, oh, they are getting too large, we need to do something about this. So on the other hand, what we've seen since I started doing this over 20 years ago is much more sophistication on the tribunal's part to use tools for valuation and assessment of compensation that are used in the real world, like discounted cash flow approach, for example, and that may have taken us to a more precise assessment of the law. So just to put that aside, I think the contractual basis disputes, as Aurélia showed this morning, are not necessarily something that is going to result in lower damages. If you think about the contractual disputes, we see a lower percentage of zero damages award and a higher ratio. And I think that the reason, and goes to Tim's point on uncertainty, if you can in the contract specify much more clear how the compensation is going to be determined, and how the different breaches are going to be assessed and what constitutes this or that other breach, that is helpful and helps the tribunal and it helps the investors because it reduces uncertainty. So in that sense, and then particularly when we see, and have just briefly a couple of examples of the new VITs, the VITs that have been signed lately, when we go, and for my particular interest is the compensation clauses. As I mentioned, the old VITs, the ones in the 80s, 90s, 2000, is a broad clause. Sometimes there's not even guidance for an FET breach, for example, in the treaty. Now the new VITs have language that I don't, honestly, having read them, I don't know if it helps with uncertainty or makes it even worse. Just to tell you about, for example, the Turkey UAE VIT of 2023, it has a clause when it gets to the damages section that it says any award on damage shall be determined taking into account inter alia an equitable balance between public interest and interest of those affected, the purpose of the measure, the current and past use of the property, the history and of its acquisition, the amount of capital invested, depreciation, duration as a going concern of the undertaking, record of profitability, capital already repatriated, replacement value, and other relevant factors. Compensation shall neither include losses which are not actually incurred, nor probable or unreal profits, may be adjusted to reflect aggravated conduct by the investor or conduct that does not seek to mitigate damages. So, yeah, I mean, at one point, we haven't had to use that clause yet, but it's going to be difficult to take all of that into account when we assess a claim. And then we have just another example that I found interesting is the Colombia-Spain VIT of 2021, where it has a clause for all damages, not just expropriation. But it's very interesting because it says the compensation will be equivalent to the reduction in the fair market value of the investment. So now we are not talking about the typical, there's an expropriation, compute the fair market value, but rather if there's any claim, compute that reduction in the fair market value. To estimate that fair market value goes further. Various valuation methods must be used, including information on recent market transactions involving comparable assets, as well as commercial and/or administrative statements related to the value of the investment. So again, it goes further to now, like even guide us towards what methods we should be using. Mandates the use of simple interest. So it has to be simple interest, but based on the cost of debt of the sovereign. So in a way, if you have heard of the cornerstone theory to interest, it's like, okay, well, we're going to use the cost of debt of the state to update damages. And there's what I found an interesting fact is that the treaty mandates the tribunal that tribunals must impose a penalty for excessive claims. So if there's a difference, if the amount awarded is less than 50% of what has been asked, the tribunals must impose a penalty of 2% of the difference between the ask and awarded. So that's another, again, I assume with the objective of limiting this excessive or perceived excessive claims. So with all of this, I think contractual disputes are going to maybe be more prevalent and not necessarily lower damages. And it's always good from an economic point of view to have that uncertainty being reduced, to have things on specified and agreed upon by the parties. Countries may, when you have contracts, as Tim said, that you have PSAs or PPAs for power, the sectors that the country wants to protect more may have different protections. So now it can be a much more tailored solution, I think, and it may work better for both parties, and maybe better than this new language in the VAT.
Well, thank you, Miguel. With that, I think we will draw our panel to a close. I would like to just say thank you to Compass Lexecon for hosting, and again, thank you to the Washington Arbitration Week organizers for their fantastic work in this conference. And finally, thanks to all of you for attending at 9 a.m. on a Friday morning. We really appreciate that.